Power doesn't just disappear, it gets erased, district by district, map by map. And if we're not paying attention, we could wake up to one of the worst rollbacks of Black and brown representation in American history. I'm Congressman Richie Torres, speaking to you from the Bronx. But this story stretches far beyond New York. What is happening now in the Supreme Court will decide the fate of Black and brown political power in the United States. The Supreme Court could strike down Section 2 of the Voting Rights Act as we know it, the very provision that affords communities of color equal opportunity to elect candidates of their choice. Section 2 is not only about access to the ballot box, it's about fair representation in government for all Americans. Section 2 prohibits states from gerrymandering communities of color in order to shrink their voting power. Without Section 2, states would be free to crack and pack communities of color, cracking them among multiple districts or packing them in one district or a few districts, all in an attempt to shrink minority voting power. Make no mistake, the loss of Black political power is not a tragedy, but a strategy for the far right. Let's rewind to 1870. The Civil War ended just 5 years ago. And now with the 15th Amendment, Black men finally have the right to vote. Almost overnight, several Black candidates actually win elected office in Southern states, giving America a fighting chance at real Reconstruction. But after Reconstruction fails in the late 1870s, Southern states began erecting barriers to Black voting, from imposing poll taxes and literacy tests to committing terror and violence against Black voters themselves. From the failure of Reconstruction all the way up to the Voting Rights Act in 1965, most of the South went a whole century without electing a single Black candidate. For example, in Alabama, it took over 115 years until 1992 to elect one Black member of Congress. Were it not for the Voting Rights Act, that number would almost certainly be zero. Let's not forget, Section 2 of the Voting Rights Act has been reauthorized 4 times by Congress. In 1982, an amendment strengthening Section 2 was signed into law by a well-known radical leftist. You might have heard of him, Ronald Reagan. Most recently in 2006, the Senate unanimously reauthorized the Voting Rights Act by a margin of 98-0. If the Supreme Court effectively eviscerates Section 2, it would mean the worst collapse of Black and brown political power since the rise of Jim Crow. The Voting Rights Act, which is the most consequential law in our nation's history, has been described by the NAACP as the birth certificate of multiracial democracy. Donald Trump and the Supreme Court are intent on signing its death certificate. But we, the people, refuse to accept the death of our democracy, and we will fight for its rebirth.